Jury number 34, it appears, since you have paperwork in your hand, that you are once again foreperson of this jury for purpose of the sentencing phase. Is that correct?
Yes, Your Honor.
And juror 34, has the jury reached a verdict as to both sentences for both counts 1 and 7?
Yes, we have, Your Honor.
Okay, could you provide the verdict forms to the bailiff, please? The record should reflect that the jurors have completed one of the 4 verdict forms for count 1 of the indictment per the court's instructions. And a quick review of the verdict forms indicates that the jurors have completed one verdict form of the 4 provided for count 7, consistent with the court's instructions. The verdict form completed by the jury as to count 1 reads, "We, the jury, being duly impaneled and sworn, do hereby find that the aggravating circumstances that the defendant was found guilty of committing do outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed upon Shawn Grate." This is dated May 18, 2018, and appears to bear the signature of all 12 jurors. Juror number 3, do you concur in this verdict?
Yes, sir.
Juror number 6, do you concur in this verdict?
Yes, sir.
Juror 49, do you concur in this verdict?
Yes, sir.
Juror 131, do you concur in this verdict?
Yes, Your Honor.
Juror 52, do you concur in this verdict?
Yes, sir.
Juror 50, do you concur in this verdict?
Yes, Your Honor.
Juror 17, do you concur in this verdict?
Yes.
Juror 87, do you concur in this verdict? Juror 23, do you concur in this verdict?
Yes, sir.
Juror 92, do you concur in this verdict?
Yes, sir.
Juror 97, do you concur in this verdict?
Yes, sir.
And juror 34, do you concur in this verdict?
Yes, Your Honor.
The verdict form then that the jury has completed for count 7 reads as follows: "We, the jury, being duly impaneled and sworn, do hereby find that the aggravating circumstances that the defendant was found guilty of committing do outweigh the mitigating factors presented in this case by proof beyond a reasonable doubt. We therefore unanimously find that the sentence of death should be imposed upon Shawn M. Grate." This verdict form is dated May 18, 2018, and appears to be signed by all 12 jurors. Juror 3, do you concur in this verdict as to count 7?
Yes, sir.
Juror 6, do you concur in this verdict?
Yes, sir.
Juror 49, do you concur in this verdict?
Yes.
Juror 131, do you concur in this verdict?
Yes, Your Honor.
Juror 52, do you concur in this verdict?
Yes, sir.
Juror 50, do you concur in this verdict?
Yes, Your Honor.
Juror 17, do you concur in this verdict?
Yes.
Juror 87, do you concur in this verdict?
Yes.
Juror 23, do you concur in this verdict?
Yes, sir.
Juror 92, do you concur in this verdict?
Yes, sir.
Juror 97, do you concur in this verdict?
Yes, sir.
And juror 34, do you concur in this verdict?
Yes, Your Honor.
Okay, the court finds that the verdict forms were properly returned by the jury. The court will accept the verdicts of the jury as to count 1 and as to count 7, both being verdicts for imposition of the death penalty. The court will file those verdicts with the clerk. Ladies and gentlemen of the jury, and this applies to the alternates as well, I wish to thank you for your time, commitment, your patience, and your service in this matter. I do appreciate the efforts you've made to comply with the court's general orders of admonitions and to be diligent about showing up timely and doing the job that you've been tasked to do. If you have any questions following your dismissal today, I'd be happy to answer those for you after court's dismissed, or if you have something you'd like to address, I could always talk to you next week too if you want to get out of here tonight, because it's now 7:51 p.m. After you are discharged, you may discuss your verdict and your deliberations with others, but you're not required to do so. You must decide for yourself whether or not you will discuss such matters, and in any event, you should be careful what you say. You should make no statement, verbal or in writing, unless you are sure that it is complete and correct. You should make no statement that you would not be willing to make under oath in the presence of the court, the other jurors, the litigants, and their respective counsel. If your statements are to the press, remember your name and your statement may appear in print, in which event you should be doubly cautious to be sure that your statement is absolutely correct, both in whole and in part, because the press will only use that part of the statement that the reporter considers sufficiently newsworthy or challenging. As jurors, you have served as public officers of this court, and when you are discharged and I leave the bench, your services are completed and you have all the rights to privacy of any private citizen. And it's the lawyer's duty, the duty of the public to protect, well, it's the lawyer's duty to protect those rights and your desire not to talk about the case. If that's your decision, it is improper and unethical for a lawyer or anyone else, press, public, media, to harass, entice, or exert improper influence on you for the purpose of getting you to talk about the case. Should that happen, please report that to the court if you feel uncomfortable. Let one of the bailiffs know. Again, I want to thank you all for your service, and you are now discharged. Thank you, ladies and gentlemen. You're excused at this time. Okay. Then sentencing will be scheduled for June 1, 2018 at 10 o'clock a.m. And the court will take the matter of the sentencing sanctions for counts 1 and 7 under consideration and render an opinion before we proceed with sentencing on June 1. I'll probably read that opinion on the 1st at 10 o'clock, and then we'll shift immediately into the actual sentencing itself. Counsel, just aside from counts 1 and 7, I ran an Excel spreadsheet on what I believe the sentencing range is to be roughly for the other charges in this case. I will probably massage that a little bit and then send it out to you by email if there's anything in there that you feel I'm off on in terms of what is the correct sentencing range for the court to consider. I'll have that out to you early next week and try to get back to me well in advance of the sentencing date, just so there's no confusion as to the potential sentences that could be imposed. Anything further today from State, Mr. Tennell?
No, sir, thank you.
Mr. Whitney?
No, sir, thank you.
Okay. Then this hearing is concluded. Court's in recess. Thank you, gentlemen.
Thank you, Your Honor.